You can be right over there.
Yeah, thank you. Please be seated.
Good morning, ladies and gentlemen of the jury. How are you today? It sounded like it was a bit festive in the hallway. Okay, we're going to move on to the next phase of the trial. This is the opening statements. It's what the lawyers think it's going to be. It's like the trailers at a movie theater. They're going to tell you what they think the evidence is going to show. It is not evidence itself. That'll come in the next phase. But with that, Mr. Zion, are you ready to proceed?
We are, Your Honor.
Ms. Grubb, I'm sorry.
Yes, thank you.
Okay, before you get started there, if you all are comfortable, you can.
As far as the masks.
As far as the mask, because you're in your own little cubicle there. Okay? I want you comfortable. Now when you go, you got to put it back on. Okay? Sorry about that, Ms. Grubb. You may proceed.
Thank you, Your Honor, defense team, colleagues, and members of the jury. Good morning. My name is Janet Grubb. It is my pleasure to finally address you this morning. Mount Carmel West Hospital was an unlikely crime scene. The hospital formally opened in 1886, having secured the services of the Sisters of the Holy Cross. The training school for nurses was opened in 1903. The first graduates received their diplomas in 1906. 8 sisters were included in the class. The school still exists today and is now the Mount Carmel College of Nursing. This location was known as Mount Carmel West and was one of the 4 facilities that comprise the Mount Carmel Health Systems. Mount Carmel West moved in 2019 and is now known as Mount Carmel Grove City. Mount Carmel Health System is the second largest healthcare system in Central Ohio. Our evidence will show that they employ approximately 9,000 total employees and over 2,000 doctors in their numerous outpatient facilities and their 4 hospitals. Mount Carmel East near Reynoldsburg, Mount Carmel Grove City in Grove City, Mount Carmel St. Anne's in Westerville, and Mount Carmel New Albany Surgical Hospital in New Albany comprises the system. Mount Carmel Health is owned by Trinity Health, a Michigan corporation. The Hospital of Mount Carmel West occupied a unique position in the areas of west and southwest of downtown Columbus, including Grove City and other small towns in the region. The hospital's ethic and profile fits the patients it served and the people who worked there. Hardworking, family-oriented, religious, trusting, generous. If you grew up in this area, chances are you stayed there. This is a painful family affair with no end of pain on so many levels. Our evidence will further show the pain relates certainly to the loss of the lives, who we will prove were murdered by the defendant, but also extends to the loss of careers, jobs, friendship, financial security, and trust in healthcare professionals and institutions. The evidence will reveal that this case unfolded one surprising step after another. The pharmacy staff at Mount Carmel West became alarmed about certain drugs ordered and administered at the direction of William Husel. Their concerns were escalated to hospital administrators, other physicians, and ultimately to the top medical officer at Trinity Health. The setting for the use of these drugs was the night intensive care unit at Mount Carmel West. These medications are powerful, potent opiates, benzodiazepines, and paralytics employed in the treatment of seriously ill individuals who are placed on ventilators to help sustain their lives. The evidence will show that these drugs were prescribed in massive doses in combination with one another. During the ongoing COVID-19 epidemic, we became aware of the use of ventilators to care for people needing life support. Being on a ventilator was not and is not a death sentence. People do come off of them and live. Unfortunately, that was not the case for the victims in this prosecution. The medical testimony in our case will demonstrate that when an individual is placed on a ventilator, they should be highly monitored and expertly managed to determine their physical state and to preserve life. This is a highly dramatic event in a person or a person's loved one's life. There are no guarantees when you go on a ventilator. If you are conscious going on a ventilator, you must know that you may never wake up alive again. This is the state in which we find our victims. Our evidence will establish that many of our victims were elderly. Some were younger than 40. They had multiple medical conditions. Many were extremely serious. They had families, lives, and people who cared about them. They went to the hospital for help. Several of them were not sick enough that they were destined to die during their hospitalization. They all had one thing in common. William Husel was the nighttime ICU physician who ordered lethal levels of drugs or a combination of drugs with their removal from a ventilator after their loved ones made the excruciating decision to withdraw care and remove them. A fair question would be, how did this happen? These drugs were obtained through Mount Carmel West's pharmacy system from a drug dispensing machine known as a Pyxis machine. They were located in the ICU. Often, Husel ordered drugs verbally and overrode the hospital's procedures for pharmacy review. At the time of the majority of these cases, in order to be within hospital policy for an override, it would either need to be an emergency situation, which our evidence will show is typically not the situation with an extubation, or Husel would need to witness the drug's administration himself. These drugs were removed in massive amounts, well exceeding reasonable dosing for the procedure of removing ventilator support. Physicians trained in their use will testify that the doses used were at levels that could not be supported by the patient's medical histories or current circumstances. They will further testify that the drugs ordered by the defendant caused the death of the victims as alleged in the indictment. The nighttime ICU at Mount Carmel West did not have a dedicated pharmacist. 2 pharmacists served the entire hospital during the night shift. If a physician ordered opiates or benzodiazepines on override from the Pyxis machine and the drug was administered, there was never pharmacy review for appropriate use. In the case of defendant's dosing regimens, his practice of overprescribing fentanyl and other drugs continued without oversight for years. You will hear how well-respected defendant was at Mount Carmel West. The nurses, pharmacists, and other doctors liked him and thought he was a good doctor. He was attentive to the patients and willing to share knowledge. Doctor of the Year honors were bestowed on the defendant during one of his first few years at the hospital. He was well known for his training at the Cleveland Clinic in anesthesiology and critical care. He was and is, in many cases, still highly regarded by many of the young nurses who worked on the ICU at night. Many new nursing school graduates, ambitious, bright, and in the defendant's thrall. They looked up to him, trusted him, and had extreme difficulty in questioning his orders or methods. His ability to verbally provide alleged reasons for his dosing, coupled with his training as an anesthesiologist, caused the nurses and pharmacists to accept his practices as appropriate and even essential. Our evidence will dispute his reasoning through our experts' explanation of the proper standards of medical care. Members of the jury, this case is a mountain of evidence, information, technical data, and criminality against 14 innocent and seriously ill individuals. Our evidence will show that this case is not about the following. It is not about fentanyl as a drug of abuse. It is not about drug diversion from a pharmacy. It is not about Medicaid fraud. It is not about a hospital system desperate to survive. It is not about taking comfort care from the dying or wanting people to die in pain. It is not about assisted suicide. It is not about criminal behavior of anyone other than the accused, William Husel. It is not about civil judgment for or against anyone involved in this case. It is not about wrongdoing by Mount Carmel as an institution or its employees, including administration, nurses, and pharmacists. This case will touch upon the following concepts: medical malpractice or negligence, group dynamics in the medical profession, financial pressures in the U.S. medical system, system failures in large institutions, the culture in the ICU at Mount Carmel West, the assumption in a medical setting of good intentions, the Catholic Church principles of sanctity of life and care for the sick, needy, and/or elderly. Our evidence will demonstrate that this case is about the following: standards of medical care, the rights of the critically ill and their families, including right to self-determination, right to the truth, and right to sit vigil over the dying as they progress towards the time of their natural death. It is also about the properties and interactions of powerful drugs, including opiates, benzodiazepines, and paralytics. We will demonstrate that our case is also about the science of maintaining the critically ill in an ICU setting, including appropriate pain management as used by other physicians at the hospital. It is about the science of managing pain within the palliative withdrawal of care, including removing a patient from the ventilator and controlling their pain and/or agitation upon withdrawal of care. This science includes concepts embodied in a set of orders maintained at the hospital and used by other ICU and palliative care physicians. Similar dosing practices comprise the standard of care in the medical profession. You will hear how these medication regimens used by other physicians involve opiates and benzodiazepines in a much lower equivalent doses. Mount Carmel's palliative ventilator withdrawal order set, in existence for all of our 14 cases, but the first, recommended a pre-dose of 5 to 10 milligrams of morphine before extubation and adjusted amounts after extubation to keep the patient comfortable. It also suggested 2 milligrams of Versed, a benzodiazepine for agitation or anxiety. Oxygen therapy was also suggested. The conversion of morphine to fentanyl is roughly 10 to 1. Translated into fentanyl, the predose would be 50 to 100 micrograms. Defendant administered 600 to 2,000 micrograms at one time. The defendant's predoses were 6 to 10 to 20 times the recommended dose of fentanyl, depending upon the patient, and 3 to 5 times the dose of benzodiazepines. The state's evidence will further show that opiates and benzodiazepines have a synergistic effect and create a medication multiplier, not a simple 1 + 1 = 2. This combination of drugs creates an overwhelming risk of respiratory depression. Our evidence will also show that after an extubation, the standard of care involves maintaining a caring presence at the patient's bedside, monitoring pain, and ongoing titration or adjustment of the medications to keep the person in a state of comfort, allowing them to pass naturally. This is in direct contrast with the defendant's practice of administering an enormous shot in a short period of time and calling it a day. Our evidence will also show that Mount Carmel Hospital System ran an internal audit, and the defendant was the only physician in the entire hospital system using fentanyl and benzodiazepines in these grossly inflated doses for this purpose. Ultimately, our case is about the fact that William Husel caused the death of our 14 victims. You will hear and see for yourselves the way this case was referred to the Columbus Police Cold Case Homicide Squad and Franklin County Prosecutor Ron O'Brien. Police involvement came on the heels of the Mount Carmel Hospital internal investigation or review of the defendant's dosing practices. The hospital's review was separate from the police investigation and resulted in the termination of Husel, pharmacy staff, and nurses. These concerns were eventually directed to his practice when he ordered the removal of people from ventilators, supporting their breathing, along with other life-preserving therapies. These homicides are loosely classified as cold cases. The reasons for that are the period of time between the death and the suspicion of foul play. Most of William Husel's victims died without any question regarding the reason for their demise. Fortunately, we have the actual medical records for each of the deceased. The records demonstrate as much relevant medical information as possible, short of an actual autopsy. Based on the drugs administered involved in these cases, the evidence of death and why they died will be clearly proven by the state's evidence. The state of Ohio will present a number of mainstream medical experts. All of them possess special certification in their medical fields. Many of them publish in their fields and teach other physicians in order to educate the next generation of practitioners. They have years of relevant experience and will testify that William Husel's dosing practices were unwarranted and unprecedented. The state's experts will establish that our victims' medical situations fall into several categories. Many were not in a position to feel discomfort, pain, or agitation. Nonetheless, they were administered large doses of fentanyl or fentanyl and benzodiazepines without being medically indicated. Several of our victims should have been maintained on life support for a longer period in order to eliminate all possibility of hope and to be observed. Others of our victims could have survived with appropriate care and informed decision-making by families. In this case, we will demonstrate that because the defendant was not acting in good faith and used drugs wildly excessive for the needs of his patients, this defense does not apply. We will present testimony from numerous physicians, nurses, and pharmacists employed at Mount Carmel West at the time of the murders. These individuals played a part in the events detailed in this case. They are not accused of criminal conduct. In each instance, the defendant ordered the administration of the lethal doses of medication. Our evidence will establish William Husel's actions caused the death of these patients. As we previously discussed, these people were quite ill and receiving care in an intensive care unit. The state's experts will establish that not all of these people were terminally ill on the date of their death, or at all during their hospitalization. We will prove that William Husel's acts were a cause of their individual deaths. We will prove through our evidence, all consistent with Ohio law, that the defendant is responsible for all of these deaths as the natural consequences of his unlawful acts, even though the victims had serious illnesses. The state does not need to prove the defendant's motive. However, his purpose will be very clear. The state's witnesses will demonstrate through actual, detailed medical testimony that given the physical condition, medical status, ages, and previous course of treatment of his patients, Dr. Husel knew exactly the natural result of his purposeful acts, and that therefore he possessed the intent to unlawfully end the lives of 14 innocent individuals. As William Husel possessed advanced training in the use of the drugs he employed to end the lives of his patients, the state will show that his actions were not mere accidental or medical negligence. They were, in fact, murder. The drugs used and the size of doses used in conjunction with other powerful drugs were important elements in determining his intent. But other behaviors were important too. These behaviors include what events were treated as emergencies or urgent, the timing of these procedures, the time of day of these procedures, how consent to proceed to comfort care was obtained and from whom. Other factors included the actual medical condition of the people that were murdered, and that some of the murdered could have left the hospital to go home or to hospice. As previously discussed, this case has many heartbreaking aspects, none more so than the loss of the patients of William Husel listed in the indictment. These people had names and families. Joanne Belisari, Ryan Hayes, Beverly Schertzinger, Danny Millette, Francis Burke, Brandy McDonald, Jeremiah Hodge, James Allen, Troy Allison, Bonnie Austin, James Timmons, Sandra Castle, Rebecca Walls, Melissa Penix. Members of the jury, thank you for your kind attention. We assure you that our case will provide all that you need to consider this case fully and to deliberate with confidence. The actions of the defendant speak clearly to us. After careful consideration of all of the evidence, we are confident that you will return verdicts of guilty against the defendant in all 14 counts. Thank you, Your Honor.
Thank you, Ms. Grubb. Mr.
Members
Bias?
of the jury.
Your Honor, we need a moment to set up. If we could take a quick 5-minute break.
Well, if I give them 5, they won't love me anymore, so how about 10? Will that give you enough time? Let's take 10 minutes, ladies and gentlemen. Remember the admonitions?
All right.
We'll get started back here in a second.